Please be seated. Thank you, Mr. Connolly. Yes, Mr. Dale.
All good, Mr. Connolly?
I'm good.
So we were talking before lunch about the declaration of the friendship, and I was putting to you, make any declaration in writing. I think you and I were both operating on the unspoken assumption that I was talking in the period up to the end of last year. Yes. All right, so because you did make a written declaration in October, November of last year.
That's right, yeah.
Now, first of all, if we can look in order at the minutes of the GWC meeting of the 27th of October 2020, that's GWC.0002. GWC.0002.0016.033. Thank you. And we see here some redacted minutes of the GWC 27 October 2020. And at number 2, the unredacted part, or item 2, Deputy Director General, that's you.
That's correct.
Who attended the meeting.
That's correct.
Disclosed a friendship with Mr. Murray, and another member disclosed a relationship as well. Now, can I ask you, did you make that disclosure of your own volition or because you were requested to?
No, of my volition.
And why?
Because Claude was coming to a Gaming and Wagering Commission meeting that hadn't happened previously, or if it had, very infrequently, and I thought it was appropriate that I told new members of that relationship.
So, why did you make that disclosure to GWC then in that formal way?
Because he was coming to that meeting, so I wanted the members to know at that meeting that I had a relationship with him.
Why did you think it was important for them to know that?
I thought it was relevant for them to know that. He
Why?
was coming to make presentations and submissions. He was acting instead of Joshua Preston, who was the Chief Legal Officer. I thought it was important that as he was making those presentations that they knew that I had a friendship and a relationship with him.
Why did you think it was important they know that?
So that they wouldn't perceive any conflict.
Why did you think, absent your disclosure, they might perceive a conflict?
I thought it was the right thing to do for them to know that I was a friend of Claude's.
I'm just trying to understand why you thought that, Mr. Connolly.
Honestly, I don't know what to tell you. I thought that at that time that because Claude was coming, it was right for me to declare that I had a relationship with him, so that they were aware, at least aware, that that friendship existed.
And was that because you had an appreciation that it could be perceived that you might treat Mr. Murray and the things he was saying differently if he were your friend rather than if he were somebody who was just an arm's length person at Crown you were dealing with in a professional capacity?
I think that's part of it, but it's also for me was an escalation of Claude's role within Crown and his dealings with the Gaming and Wagering Commission. He was coming to make a formal presentation to the Commission.
Thank you, Mr. Connolly. I tender those redacted minutes, Commissioner.
Can you read the number out again,
Yes.
please?
GWC.
And the date?
Yes, it's the minutes of the 27th of October 2020. The Bates number is GWC.0002.0016.033. I'm not sure, it doesn't carry an underscore R.
Excuse me, the
Sorry,
redacted minutes
Commissioner,
of the...
Commissioner, can I just interrupt? I apologise. I'm told that it's important that I add underscore 0001 to the end of the number.
The redacted minutes of the GWC meeting of the 27th of October 2020, bearing the document identifier number that Ms. Cale has just read out, will be admitted into evidence, as an exhibit.
And I think I'm being told another story again, that the Bates number needs to be, as I apprehended, GWC.0002.0016.0333
Thank you.
Now, another document to tender is the document number. MCN.0002.0001.0001.004. That is, Commissioners, you'll recognise that as an annotated version of Annexure B to Mr Connolly's witness statement. I tender that document.
The annotated version of an email from Mr Connolly to Mr Sargent, dated 13th of October 2015 and bearing the identifier number MCN.0002.0001.0004 is admitted into evidence as.
Thank you, Commissioner. I now call up document MCN.0002.0001.0002. Now, can we just shrink that document a little so that Mr Connolly can see it as a whole, please? Now, do you recognise this document, Mr Connolly? I'm not showing you the whole thing, there's also a back page as well.
I do.
And if we just drop down to the back page or turn over to the back page. Thank you. Is that your signature there?
It is.
Above the date of the 17th of November 2020.
It is.
Did you fill out this form?
Yes, I did.
Right. And if we just go back up to the first page, please. This declaration of conflicts of interest form, is that a pro forma document or template document that has been in existence in the department for years or only recently?
I think this form is an annexure to the most recent conflict of interest policy.
Which dates from when?
2019, 2020.
Understand. And did you fill this declaration form out of your own volition or at the request of somebody?
I believe that following the Gaming Wagering Commission meeting, the Director General suggested I fill this document out.
Flowing on from
that, yes.
the declaration you made
Yes.
at that meeting.
Yes.
All right. Now, in the box, the third row down, the conflict of interest has been identified as an, and then you've got to check a box.
Yep.
You checked the boxes.
I did.
For perceived or potential conflict.
I did.
You didn't tick actual.
I did not.
And on reflection, should you have?
On reflection, I'd still, for an actual conflict, I think I would have to have done something knowingly in the interest of somebody else, and I haven't done that.
Right, so just so that we have it for the transcript, Mr Connolly, because you've done that there in handwriting, could you please read out
Sure.
what you've written in the box underneath that?
Personal relationship with Claude Murray from Crown Perth. We are friends and regularly fish together. Matters that may be perceived as a conflict of interest relate to issues relating to Crown that Mr Murray is involved in preparing.
Thank you. And underneath that you identify expected roles, duties to be performed by you in dealing with this matter, and you've listed there Deputy Chair GWC, Deputy Director General and Chief Casino Officer.
All of them, yes, that's right.
All right. And just coming back to the explanation of the personal relationship, the way you've articulated it there, do I understand correctly, you perceived that to be something that should be declared to whom?
Well, in this case, to the Gaming and Wagering Commission, but also to the department,
Right.
so to both.
Well, it says at the top, this form's to be used by an
Department.
employee of the department.
Mhm.
So it's a declaration to the department
Yeah.
as well as the GWC.
Well, I think I'd did the GWC declaration verbally at the meeting. I'm actually not aware that there is a GWC form for this, but this is the department one. Yeah.
Right. And just so that I'm clear, did you really mean to formalise your declaration to GWC by completing this document?
That's the intention that I had as well, yes.
Did
But
you-
also to tell the Director General.
Why the Director General?
Well, just so I'd covered both the department and the Gaming and Wagering Commission with the declaration.
All right, so when you made that declaration to cover the bases, as it were, with the department, did it give you cause to reflect on whether you ought to have made a more formal declaration at an earlier point in time about that friendship to the department?
It was a bit late in November 2020 to think about that, but certainly I think I could have done much better. I think I'd said that earlier on, that I could have done that, and with reflection and hindsight, I would have done that, yes.
Now, let's imagine that you had, at some point before 2020, how would you have envisaged that the conflict could have been managed? First of all, in relation to Mr. Hume, secondly, in relation to Mr. Murray.
Well, I think they probably would have. There's probably no difference between the two in how they would have been managed, and that would be up to my manager or the Gaming and Wagering Commission. But I think they would have been, and we're talking hypothetically here, I think they would have been satisfied with the declaration and understanding that relationship. I don't think they would have excluded me from anything, but that's probably a decision for a discussion for the GWC members rather than me. I think they would have been happy with the declaration.
And you don't think that they might have, that the management of the conflict might have involved, for example, somebody else reviewing your recommendations or decisions?
I don't think so,
Something
but again, that's hypothetical. I mean, I don't know what's in the mind of every commission member, but I don't think so.
Just taking it away from you and speaking more generally about the department, you mention in your witness statement to the effect, I think these are more my words than your words exactly, that you know people working in the department in areas related to casino regulation who have partners, friends or family also working at Crown.
Or have had, yes.
Do you mean working at Crown in the area of regulation?
In areas that are regulated, yes. Not in the areas of regulation itself, in areas that are regulated. So
Do you mean like croupiers or?
That's what I mean, yeah. Mm-hmm.
About how many are you talking?
I don't know. I know of a couple of examples, maybe 2 or 3.
Right. Does that include casino inspectors?
As?
Those people who have a relationship with somebody working at Crown?
Yeah.
And have you ever had a concern in your mind about a casino inspector carrying out their function of inspecting an activity that's regulated when they have a friend, family member or similar working in the regulated area?
No, I haven't. I would expect that they would advise a supervisor or a senior inspector or a director if that has occurred, and I'm not aware that it has. But there are other controls in place as well, and people in those activities don't have any real ability to influence decisions or casino inspectors in any way, shape or form, I wouldn't have thought.
Well, they have to prepare reports, don't they?
Casino inspectors would prepare reports of audits and inspections, yeah.
Yes, but a casino inspector, for example, conducting a physical inspection of how games are played or supervised, and they've got a relative who's actually a croupier. Does that raise any concern for you?
I'm not aware that that's actually happened, and my expectation would be that someone wouldn't audit their relative.
Could you say that again, please?
I would have an expectation that someone wouldn't audit their relative, but
Would
there's no policy or position around any of that.
When you say you have an expectation, are you saying you think it would be inappropriate for an inspector to inspect, audit or report upon the performance of the conduct of a Crown employee who was a relative of theirs?
Inappropriate? I think it would be better for that not to happen. And if it was happening, if they were allocated a task that required that, I would think that they would advise the senior inspector and somebody else would do that. But again, I'm not aware that that has happened.
And there's no requirement for casino inspectors to do so, I understand from your answer.
I don't believe so, no.
Right. Now, just a slightly different question. Have I tendered those documents? I've got to tender the this declaration form, which is MCN.002.001.002, Commissioner.
The Declaration of Conflicts of Interest form dated the 17th of November 2020 with the document identifier MCN.0002.0001.0002 is admitted into evidence as an exhibit.
Here, and I call up now MCN.0002.0001.001, which is a related document. And that's the covering email for the conflict of interest declaration form, the Commissioners. I'll tender that.
The document, which is an email, with the document identifier MCN.0002.0001.0001 is admitted into evidence as an exhibit.
Thank you, Commissioner. Now, a slightly different question, Mr. Connolly, or series of questions about casino inspectors with reference to page 31 of your witness statement, that's 0031, at paragraphs 281. Page 0031. Do you have that in front of you on the screen? Yeah. So here, as I understand it, you're making a point about the practical reality of casino inspectors employed over the longer term, becoming familiar with Crown employees who they see on a very regular basis through their inspection and audit programs. Is that essentially?
That's essentially what I'm saying, yes.
And you say that there's necessarily a familiarity that builds up over time between Crown employees and department employees.
Yes.
Because of the time they spend working together.
Yes.
And that leads to friendships developing in a number of cases of which you're aware. Is that right?
Yes, that'd be right.
And would you be able to put it, because you've been in this casino regulation area for so long, could you give us some kind of indication of just how frequent this problem is?
In more recent times, so post 2015, I don't think it's quite as frequent as it has been in the past. But certainly in the earlier days of my career at Crown, in the early 90s, it would be very frequent. Most inspectors, I would suggest, would have had friendships with people who would work at Crown.
All right. And the
existing and new friendships. So, you know, you do come across people that you've already known who work at Crown. So they form friendships as well.
And you mentioned 2015 as where it's the incidence of this happening has decreased. Is that because there's less of a physical presence of inspectors at the casino now?
So I have no data or evidence to point to for this, but I'm suggesting that would be the case because they're not there all the time. They go there for the purpose of audit and inspection.
So they just spend less time together?
They spend less time together. And when they are together, they're there for a purpose and they leave.
Now, do you consider that such friendships should be declared by the casino inspectors when they are formed?
It's a very difficult thing because I think realistically some couldn't be perceived as a conflict, even potentially as a conflict, depending on the position that the casino employee is in. It would be a case-by-case determination, I think.
As to whether they were in effect inspecting and auditing their friend?
Yeah, or whether they were inspecting and auditing someone who had who would constitute a conflict of interest or be a problem in that way.
And have you ever turned your mind to how that could be managed?
No, not really. Declaration, I think, is the best way, and regularly declare.
Right, at paragraph 290 of your witness statement, page 31, just the little lead into that paragraph, you're talking about how if you work in casino regulation or you work in the casino operations, you develop a degree of specialised knowledge in relation to casino regulation.
Yeah.
And casino operations.
Yep.
And that has led over the years, as you've witnessed, to Crown employees moving to the department and department officers moving to Crown as employees.
It has, yes, right.
And you say that you understand that there's no prohibition on that occurring. Do you consider that there should be?
No, I don't think so. Not necessarily. I don't know what that changes. But I know that in other jurisdictions for regulators, there are 12-month, generally a 12-month period where you can't go and work for a casino licensee. But I don't know what that changes necessarily. It put 12 months worth of time between the two jobs that they've taken, but does it change anything? I don't think so.
Well, what about something like if you're a department officer involved in casino regulation, particularly at the policy level, you move across to Crown and you might have internal information and knowledge about the direction where regulation approach and policy is heading, and you could influence how Crown reacts to that. Is that something that would cause you concern?
Probably not necessarily, because in terms of policy decisions like that, we would consult with Crown anyway, so they're going to find out about those sorts of things through a process of consultation anyway.
Now, you don't hold the position of Chief Casino Officer at the moment, do you?
No, I don't.
Do you remain Deputy Chairperson of the GWC?
I am not aware that has been revoked or rescinded in any way, so as far as
perhaps
I'm
you do.
aware, I am, yeah.
Do you remain Deputy Director General of the department?
I'm not performing that role, but I'm not aware that I've been removed from that position at all.
And do you know if your delegations from the GWC are still in place in respect of your role as Deputy Chairperson and Deputy Director General?
I don't know, I have not been advised.
Do you have any regulatory role which you retain at the moment as Deputy Director General?
No, I'm currently working on a single project.
And how long is that expected to last?
I think that was given to me on a 6-month basis, so I don't know what's happening after that.
And this is developing a banned
drinkers register and takeaway alcohol management system, that's right.
And which department are you doing that for?
Department of Local Government, Sport and Cultural Industries.
All right. And who are you reporting to in that role?
Director General.
In terms of I'm trying to find neutral language to use here, the relinquishment of your role as Chief Casino Officer, how was that affected? How did it happen?
It was a conversation about what was an appropriate way forward after media articles, and I agreed to step aside from that position. Now, how that was affected, formally. I don't know. I agreed to that though.
Who was the conversation with?
The Director General.
Mr. Ord.
Yes, Mr. Ord.
And can you tell me when you had that conversation?
No, shortly after the media article. So I am guessing here, but I think it would be early March.
So is your evidence that there were articles actually published in the newspaper and then you had a conversation with Mr. Ord about no longer being Chief Casino Officer?
That's my recollection, yes.
And what was did you discuss why you should step aside because of those media articles?
We had a discussion, yes. I don't recall the complete, what we actually talked about, but it was, I'm sure we got to the determination that my position was untenable until this matter was resolved.
And did you think your position was untenable until?
I thought it would make it easier on everybody if I did step aside from that position until the matter was resolved.
Now, I want to change topics and not talk about conflicts of interest now. I want to talk about regulatory policy and also talk a bit about junkets. Now, if I can return you to paragraph 115 of your witness statement at page 0014. Appreciate that you're talking about here policies in relation to how the Chief Casino Officer performs their role. But I want to look at the paragraphs between 115 and 119. If we just pop that paragraph back in, please, and just enlarge the page. Oh, okay, thank you. And you see at 116, you're talking about GWC policies being largely aimed at external parties. Are you referring there to the sorts of policies that are contained in the casino manuals?
No, there I'm referring to policies that are targeting, more targeting external regulated entities, so policies that relate to community gaming, again, how to conduct bingo, continuing lotteries, poker and those sorts of events.
I see.
There are no, that I'm aware, there are no real, no commission policies relating to the casino itself. They're captured.
I see. You remember we were talking about casino, the casino manual or manuals earlier today before lunch. Do the manuals contain anything about procedures for junket operations?
They do.
And can you tell me in broad form what they are?
They are very limited, so they'll have details of what the casino licensee will do in terms of checks for players, and also details of the commission programs that junket operators can participate in.
Right. I don't want to hear about the latter, but the checks for players, can you recall, I appreciate it could be hard without access to the manuals themselves, but can you just recall as best you can what kinds of checks the casino operator is required to undertake?
In accordance with the manual, I believe it's world checks. I'm not quite sure what that world checks. I think that's what it's called. It's a external company, a consulting company that will do financial and other checks on people.
What purpose?
To see if they're able to pay their debts, and I believe it also looks at their reputation and criminal history as well, if that's available. It's background checking for those players to satisfy the casino licensee rather than the regulator.
Now, just on junkets, if we can go to page 0021 and begin at paragraph 183, please. And you begin to discuss junket operations here in your witness statement. And at 184, you say historically GWC and government more generally took the view it was important to know who was conducting junket operations for probity reasons. A couple of questions arising out of that. First of all, when you talk about government there, are you referring to the department?
I guess government more generally because they were in regulation, so they have to be approved by ministers. So the requirements were in regulation.
Right. Now, those regulations in relation to junkets were introduced in 1999, you recall?
I don't recall, but yeah.
Do you recall any view before those regulations were introduced? I can tell you in about 1999, about whether junket operations needed to be regulated for probity reasons.
Honestly, I can't recall, no.
So when you were a casino inspector in the 1990s?
No, I don't recall.
And when you refer to probity reasons there, amongst others, are you referring to an acknowledged correlation between junket operators and the risk of criminal association and money laundering?
Certainly when junket operators came in, while those regulations were in place, they were required to provide police clearance certificates, both national, Australian national, and overseas. They were asked for overseas clearance certificates as well. So that was part of the probity requirement for a junket operator, yeah.
Yes, but why they, rather than any person who walked through the door of the casino, were required to have these checks, was because the view was at the time, as far as you were aware of it, within the GWC and government, was that there was an understood correlation between junket tour operations and the risk of criminal association with those operations and the risk of money laundering associated with those operations.
That's not how I understood it. The view there was because my view as a level 3 casino inspector would be because that's what was in the regulations. I wouldn't have correlated that with money laundering or criminal activity. I was working on the requirements in the regulations.
All right. Did you ever get to the view yourself where there was an association between junket tour operators and the risk of money laundering or criminal infiltration?
I got to the view that that the people that were coming into the casino as part of junkets and as part of organised junket play and VIP play were very high wealth individuals, influential individuals, and there probably wasn't a great deal of value in getting clearance certificates from their countries of origin because they could probably procure those through any other means other than law enforcement.
Did you ever come to the view that there was an understood association between junket tour operators and the risk of money laundering or criminal infiltration of those tours?
No, I didn't come to that view myself, no.
You've never had that view?
Obviously, in more recent times, then those things have been highlighted, but as a government casino inspector, we don't have access to that sort of information.
So in recent times, since when?
2019, we're through the media inquiries. We've never done probity on the junket players. We don't do probity on players. Operators have been ones we do probity.
But not for reasons related to risk of money laundering or criminal
I don't believe so.
infiltration.
I don't believe so.
So when you refer at 185 to, is this GWC undertaking its investigations when probity considerations were to the fore as you've described them, then GWC sought input from WAPOL. What I want to ask you there is why are you focusing on GWC here rather than the department?
Because they were Gaming and Wagering Commission regulations, and that was the Gaming and Wagering Commission. Department did this. I'm not sure I quite get where you're going with the question. What do you?
Well, probably just want you to answer it really.
Yeah.
Why did you've been very clear in your evidence that the majority of your work performed as a casino regulator was in your capacity as Deputy Director General of the department. And that your role in relation to GWC was Chief Casino Officer, Deputy Chairperson.
Yeah.
So here, when you're talking about junket operations, you're talking about GWC. Was it GWC who was in fact regulating junket tour operators, to your knowledge, after 1999, or was it the department?
On behalf of, I believe it was the department on behalf of, so I've probably worded that incorrectly.
Department on behalf of, because GWC was the one that promulgated the regulations.
Yeah. And the GWC doesn't have any of its own resources to actually do these things. They were done by the department. Officers of the department who are authorised officers of the Gaming and Wagering Commission.
Oh, just going back to what we were talking about before lunch. So all the decisions that the GWC made in meeting and so forth that you gave effect to,
Yeah.
they were decisions that you implemented on behalf of GWC as an authorised officer of GWC.
Depending on the circumstances, I mean, I'm doing things. I'm doing things as the Deputy Director General with the delegated powers given to me by the GWC, and I'm instructing officers of the department. I don't have the ability to instruct officers of the department as an authorised officer, but I do as the Deputy Director General.
Right. Point of clarification. So you've got GWC undertaking its investigations and then providing information to WAPOL, who would then inform GWC if a tour operator had any concerns.
If they had concerns. Yeah.
I see. And at 187,
I believe at the time what was asked for was an opinion from the Commissioner of Police.
all right, now 187, you talk about this system having certain benefits, and if we go over the page, I just want you to explain a term you use. So it had a benefits in relation to inspectors who are at time-based permanently at the casino to attend and witness junket buy-ins. Can you just explain what a junket buy-in is?
So as part of a junket process, a junket operator would come into the casino with an amount of funds that they were going to use for junket play. They would buy in, that is, they would put that money in the casino cage, and in exchange for that, they would get what was called a chip purchase voucher. They'd use that chip purchase voucher at a table to be given chips. They were given a different set or different stock of chips to normal play. So normal chips are referred to as cash chips. They use non-negotiable chips. So those chips were used to be able to track their turnover for the purposes of calculating commission payable to junket operators.
I see. Now, at 188, you mention, if we can bring 188 forward, that GWC stopped approving junket operators in 2009 or 2010. You expressed that as your understanding because you were actually at Fisheries at the time, were you? And had no involvement or input into the decision to stop approving. Now, at 191, at 189 to 191, you give, as I understand, an explanation of why you think the regulations were repealed. And do I understand this correctly? Your agreement with with that decision?
Yes, you do. Yeah, I agree with that decision. Yep.
And that culminates at 191. In terms, you're saying, well, AUSTRAC started monitoring suspicious transactions, suspicious money transactions, and as a result of that, there was no added regulatory benefit to GWC monitoring junkets.
Yep.
So you understood AUSTRAC was monitoring suspicious transactions for the purpose of detecting law enforcement agencies detecting money laundering?
That's how I understand that, yes.
And so did you therefore understand that what GWC had been doing was trying to detect suspicious transactions for the purpose of sharing that information with law enforcement
No,
agents?
I don't think I made that link, no. I don't think it was ever within the powers of the Gaming and Wagering Commission or the capabilities of the Gaming and Wagering Commission, the department or its officers to detect money laundering.
I'm not suggesting that, Mr. Connolly.
Yeah.
You've said that, as I understand it, at 191, when AUSTRAC came into being and started monitoring transactions as suspicious ones to then share that information with law enforcement agencies, there was no added benefit for GWC to approve junkets.
And I'm talking there about probity. There was no point to those probity considerations, because if these people had gone through all these other processes, then there was no added benefit to that.
Well, you're just talking about AUSTRAC monitoring suspicious transactions here.
I said coincided with that, yeah.
So you still maintain that your understanding of GWC's role before this in approving junkets wasn't related to identifying suspicious transactions?
That's not how I understood it, yes.
In any event, you returned in 2012 and to casino regulation, and you're aware then that there's no requirement for junket operators to be approved by GWC, although there had previously been a requirement. Now, at 193, if we can just cursor down, please. You say department continued to commit its resources to revenue and taxation issues and ensuring that arose as a result of the junkets occurring. By that you mean just making sure that the tax and revenue was properly accounted for?
Yes, that's correct, because there's a lower tax rate on junket play.
And ensuring integrity of gaming and other transactions.
Yep.
But not trying to identify suspicious transactions in a money laundering sense. And do I understand from your evidence that you say, well, it was appropriate for GWC to confine its focus of regulation in this way because that's what it had the capacity to oversee? And
in my view, that it was overseeing the gaming operations of the casino. But I agree, it didn't have the capacity to do anything else.
Well, let's look at 196. Paragraph 196. And you say, well, you want to raise these two things, skills and resources at the disposal of GWC and the legislative regime. Let's talk about skills and resources first. You say, well, the GWC does not have the skills or the resources to investigate money laundering, trace the proceeds of money laundering, detect those crimes and enforce the law.
That's exactly what I said, yes.
But it can do what it used to do, which was simply run some checks on junket operators before approving them, couldn't it?
It could, but is anything added by that process other than some additional burden and bureaucracy? I don't think there was any value in that, and I'm not aware that anything actually ever came from that process in terms of actionable items for outcomes for the GWC.
Well, let's stay with the approval process that was in place under the 1999 regulations, which provided that in terms that before a junket operator could organise a tour to Perth Casino, they would need to get approval from the regulator, and that required the provision of details such as criminal records, authorisation for WAPOL to access criminal databases, passport details and the like. Yes?
Mm-hmm.
That's not particularly burdensome, is it?
If those things are getting done as part of other checks, though, as part of visa applications and the like, why do that twice? But it's not burdensome for the department. There is a cost involved to the department, and it does take some time. But is that a duplication of effort? I think the other part of this, if I do recall correctly, was about duplication of regulatory functions at the time. So I don't know if that's a duplication of. I don't know what the Commonwealth agencies do, but...
Well, you either understood it to be a duplication or not.
Well...
Did you look into that?
No, I did not. No, I did not.
So did you discuss with WAPOL at any point after 2012 whether it would be assisted by having the sort of information it used to have under the regulations from GWC in relation to junket tour operations?
No, I did not.
Can I go to paragraph 207, please? Just on this concept of duplication of resources. Is your proposition here that a decision about whether or not to grant a foreign national a visa to enter Australia is a suitable proxy for a decision about whether or not to allow them to operate or participate in a junket tour to Perth Casino?
Yes, that's my proposition.
Why do you say that?
Well, if they're allowed to be in the country, they're allowed to enter the country and visit and do other things within the country, why would we stop them from... Why is there a higher standard to enter the casino and game in the casino?
This would exclude Australian citizens or dual citizens who operate junket tours, wouldn't it? That analysis that you've just given?
Perhaps it would, yeah.
Does that cause you any concern?
No.
Do you assume at the point of entry to Australia, when a visa is granted, that it's known to Border Force, or however they're described these days, that the person is organising or participating in a junket tour?
No, I don't assume that. But again, if they're considered suitable to be in the country, they've got through whatever checks they need to get through in terms of criminal history and whatever background checking is required for a visa.
Well, what are those checks, Mr.
I don't know.
Crowley?
I don't know.
Well, wouldn't it be an idea to find out before forming the view that it's a suitable, that granting someone a visa is a suitable proxy for determining whether they're an appropriate person to operate a junket tour to Perth Casino?
Perhaps, yeah.
Do you assume that no one is let into Australia who has a criminal record?
No, I don't assume that.
Or if they have any association with criminals, they're not allowed into Australia?
No, I don't assume that at all.
And these views that are expressed at 207, which you consider that GWC appears to have agreed with in the past, did you ever discuss those views with WAPOL before reaching them?
No.
Now, 208, I think on the same page, you then move to comments on, in that paragraph and following, about AUSTRAC. And if we go to 209, the effect of what you're saying there is this, isn't it? That neither GWC nor the department can obtain any relevant information from AUSTRAC about suspicious transactions.
That's how I understand it.
Has, to your knowledge, GWC or the department ever asked AUSTRAC to share information with it?
We have had meetings with AUSTRAC. I have been involved with meetings with AUSTRAC and asked about that process, but it hasn't been pursued, no.
When were those meetings?
Look, I don't know, but 6 years ago.
Right. And when you say the process wasn't pursued, sorry, I might have misstated. How did you answer that question?
So there is a process by which we could go. So we have to be, as I understand this, have to be recognised as a law enforcement agency. And when it was explained to me by AUSTRAC representatives, it was a very difficult process, and they indicated that it would be unlikely to be considered by AUSTRAC as a law enforcement agency.
That was about 5 or 6 years
About
ago.
5, 6 years ago, yeah.
At 212 of the witness statement, what you're identifying here is that Crown has an information sharing relationship with AUSTRAC, as far as you're aware, but
Yes,
that
I do.
information can't be shared with
That's correct.
department. And at 212, you say there, I understand that where issues have been found by AUSTRAC, they've largely been addressed in a satisfactory way. And what you're referring to there, where AUSTRAC has raised a concern about a transaction that involves Crown, and Crown has responded to AUSTRAC.
A transaction that involves Crown or an audit of Crown? and the Crown's response to the audit findings. So they have in the past attended gaming and wagering commissions and provide meetings and provided briefings on those responses.
Yes, so you're hearing from Crown that it has largely addressed in a satisfactory way issues that have been raised with it by AUSTRAC.
Correct.
Should that be good enough for you?
Considering that, again, in my understanding, we don't have the ability to interrogate AUSTRAC or to ask Crown about its suspicious and financial transaction reportings, I think that was the position that I took. That had to be good enough.
Could GWC or the department, if adequately resourced, in your view, inspect and audit Perth Casino's cash and electronic transactions to see any indicia of money laundering?
Without access to financial and suspect transaction reporting, yes, I think so.
And you could then refer any of those indicia to WAPOL for investigation?
Yes.
Is there any reason why it doesn't do that now?
Because we don't have the skills or the resources to do that, I don't believe.
You don't have the skills.
Or the resources.
So skills, people who can identify the indicia of money laundering in a set of books. Is that what you're saying?
That's what I'm saying. Yeah.
And is the resources just the funding to go out and find the people who have those skills?
Well, yeah.
Don't have that funding?
No, don't have that funding.
And
we have a very generic inspectorate who do a range of generic activities across a whole range of regulatory functions.
If we go to paragraph 218, say the contention that has been properly, I'm paraphrasing,
yes,
popularly sprouted in the media about GWC and department's role in ensuring money laundering does not occur is to me nonsensical. Well, nobody can ensure that money laundering doesn't occur, can
Agreed.
they? So that's nonsensical.
Agreed.
But it's not nonsensical to expect GWC to exercise its inspection powers to identify indicia of possible money laundering and to then share that with law enforcement agencies, is it?
It would be a duplication of somebody else's role, I believe, but no, it's not impossible.
Would you agree it would be entirely consistent with regulating Perth Casino in the interests of the public of Western Australia?
Yes.
Now, if I can just take you back to paragraph 120 of your witness statement at page 0015, you're referring here to conversations you have had yourself with representatives of casino regulators in other jurisdictions.
Mm-hmm.
All that part of your witness statement?
I do.
When you interact with other casino regulators, which hat have you got on? Department, GWC, Chief Casino Officer, which hat?
Department.
All right.
Generally.
And you say at 122 that the common interest between regulators in the discussions you had were in respect of probity and suitability issues.
Often, yes, that's correct.
The West Australian casino regulator, I use that umbrella term to describe either the department or GWC or both, to your knowledge, have of interest probity and suitability issues other than the circumstances in which a casino employee was to be given a licence?
Probity and suitability of Crown as an organisation and an operator?
That's of interest to
yes, it is.
The regulator
yes,
in
it
Western
is.
Australia?
Yes, it is.
How long has that been an interest for the regulator in Western Australia?
I think the probity and suitability of the operator has been an interest forever, since 1984.
And what contributions has the Western Australian casino regulator made to the discussions with other jurisdictions?
In respect of the probity and suitability from time to time, we have participated in joint investigations, and when I say that, the Commission has provided funds to help pay for joint investigations and has relied heavily on the work of other jurisdictions in considering the probity and suitability of the casino operator.
but not actually conducted any investigations here.
Not that I'm aware of.
Is there a reason for that?
Again, probably the skills and resources and the technical nature of those things. The Gaming and Wagering Commission has provided funds to get suitable people to work on those things on their behalf.
All right, now at paragraph 127 of your witness statement, page 0015, you identify two matters that you've had the more recent greatest cross-jurors interaction about. One is the Melco transaction, and the second one, the potential responses to the risks of money laundering. Now, is that something that's been of recent concern to the regulators in Western Australia, or regulator in Western Australia?
Yeah, I believe it has, yes.
But it hasn't always been?
It hasn't always been, no.
So when did that become something of concern to the West Australian regulator?
I think probably it became of greatest concern 2018-19, following media reports.
Does the West Australian regulator consider itself to have any responsibility to manage money laundering risks in relation to Perth Casino?
I can't speak for the West Australian regulator in total. Certainly my view is that they don't have any responsibility.
And when you speak at 131 of your witness statement, at page 0016, can you pop that back in, please? Just so that we get the context of it. In relation to junket operators and money laundering, you explain at 129. You made a suggestion about a national framework, did you?
I did.
Yeah.
To the Gaming and Wagering Commission, I did.
As you've and then that was then explained to regulators in other jurisdictions.
It's been discussed with regulators in other jurisdictions, yeah. But the idea hasn't been progressed in any meaningful way at this point.
And you explain the purpose of this national framework at 131,
Mm-hmm.
and one purpose you mention is to set clear expectations that could be achieved within existing legislative and resource frameworks.
Yes.
Or constraints, I beg your pardon. Is your position that WA has neither the legislative framework nor the resources to address money laundering risks?
I think there are a framework and agencies across Commonwealth and states that can address money laundering risks, and we can be part of that, but with a clear understanding of who is doing what. At the end of the day, AUSTRAC don't report anything to the WA regulator. They report to law enforcement with title links to law enforcement at WAPOL. I think that would be a better way for us to be able to deal with those things.
But what would you be doing in that, you being the regulator, do in that scenario?
Well, the Gaming and Wagering Commission can then, through directions, policies and procedures manual, have Crown change whatever processes it needs to change and require of them whatever is appropriate.
So react
within the constraints of the WA legislation.
So react to evidence of money laundering brought to you by other agencies, and to then deal with the regulations consequentially.
Potentially, yeah.
Understand. Now, 132, at paragraph 132 of the witness statement, you referred to another area of interaction, if I'm understanding it correctly, that where the department became aware that Victorian authorities had commenced an investigation into Crown's junket activities in China. Yes?
Yes.
And you understood, did you, that investigation arose because of a concern about possible unlawful behaviour by Crown or the junket tours that were associated with criminal elements?
Yes.
And you understood at the time that inquiry commenced in Victoria that Crown was marketing junkets from China to Perth Casino?
Yes.
And yet at 133 you say the GWC considered it would take no action until that Victorian report was finalised.
So again, GWC were going to rely on the outcome of that report.
Did this have anything to do with the department? Was it entirely GWC's decision?
No, that was a decision of the GWC, I believe.
But it has nothing to do with the department?
I don't believe so.
No departmental officer was involved in making recommendations to GWC?
I may have made a recommendation in relation. I don't recall making a specific recommendation to the GWC about this, but possibly.
To wait until the report was finalised?
Yes. Now, that wouldn't be something unusual. I would have done that before.
Was GWC, to your knowledge, given any estimates by Victoria about the time it would take for the report to finalise?
Yes, I believe they were. There was also a couple of impending timeframes that when the report was going to be finalised and released, but the Bergen inquiry commenced and they determined for their own reasons not to release that report.
What was the time estimate that was given?
It was certainly going to be before the Bergen inquiry report was released, so it was prior to February 2019.
Well, the Bergen inquiry was announced in about August 19, wasn't it?
Yes, but it was before that.
But you talking about the department becoming aware of the investigation in Victoria in
2017, yeah.
So what sort of estimate were you given by Victoria about?
I don't recall. It was pushed out a number of times.
Right, now 137, just want to understand what you say here. This ultimately meant that while junket operators had been on the radar of GWC for a number of years, had not taken any significant action of its own to investigate. When you say a number of years, what are you talking about there?
2017 to 2021.
Right, and when you say on the radar, do you mean that GWC and or the department had been aware that junket operators had been associated with allegations of money laundering and criminal infiltration?
No. What I'm saying is the issue of money laundering and the potential for criminal infiltration was on the radar. Not that they were aware of that, but that was an issue, a contentious and relevant issue.
Yes, I'm not saying it actually happened,
Yeah,
but it was an area of concern.
It was an area of concern, yes.
Yeah. And are you saying at 137 that the primary reason why GWC/department did not take steps to conduct its own investigations was because of resource constraints?
And that other reliable regulators were conducting that work as well. And when the Bergen inquiry was announced with the terms of reference of the Bergen inquiry, that was a Royal Commission with, infinitely more resources than the department or the GWC.
Just talking about your own position as someone advising GWC at the time, while those investigations and inquiries were working their way through the system, did you have any concern about the risks that the public of Western Australia were being exposed to in the interim in respect of junket tours coming to Perth Casino?
No, I think I was satisfied that the inquiries were underway.
So yes, but those could take years, and they did take years.
They did.
So in the meantime, the junket tours keep coming, and there's a concern around allegations of an association of junket tours with money laundering and criminal infiltration. You were content, were you, for those risks to remain there while those inquiries work their way out?
Well, those weren't necessarily decisions for me. From my perspective, I was content to wait for the outcome of those inquiries. The Gaming and Wagering Commission had the opportunity to do other things if it chose to do that.
But they were acting largely on your advice, weren't they, Mr. Connolly?
Well, they're also a group of intelligent individuals who can make their own choices. But yeah, I'm sure that they took my advice into consideration.
Well, you were the experienced casino regulator, not they. Would you agree?
I agree, yes.
and you could have recommended to them that junket tours be suspended or banned while those investigations were being completed in other
I
jurisdictions.
could have.
You didn't,
I didn't.
and why not?
Because I didn't think that was a necessary step at that point in time.
Why not?
Well, that was a judgment call made by me.
I'll leave it there, Commissioner, in order to allow some time for cross-examination of
All
other
right,
parties.
thank you. Has the bar table got an order?
We haven't had an opportunity to confer on that, Mr. Chairman, but from my perspective, it might be in light of what you said this morning that we will defer any cross-examination till the second occasion upon which Mr. Connolly returns, in which case we can assemble some documents that might make the process a little bit more swift.
You happy with that? Mr. Evans?
I was going to defer to Ms Seward in the first instance.
Seward?
Just a couple of short questions at this stage. Thank you. Mr Connolly, you were asked a large number of questions about the role of the department and the various officers and the interaction with the GWC. Primarily, what is your understanding of the role of the department in terms of how it interacts with the Commission?
The department provides the resources for the Commission. The Commission has no resources of its own. So the department provides resources for the audit, inspection, regulatory functions more broadly.
Those resources are provided to enable the Commission to carry out its statutory functions. So the various officers in the department that have that as at least part of their role, they're carrying out those tasks for Commission purposes, if I can
Yes.
put it that way. They are, however, employed by the department.
The department is correct.
And so who in the department is ultimately responsible for the department providing those services to the Commission?
Ultimately, the Director General, I believe.
Now, as part of your role, you were involved in preparing agenda papers, we heard. With those agenda papers, do they follow some sort of pro forma? Is there a standard items that need to be included?
There are standard items, yep, that's correct.
And so to the extent you have any discretion about what goes in, how much discretion do you actually have in relation to the topics that are brought before the Commission?
So there's a standing agenda with standing items. I would have discretion in relation to new business that's brought into Commission meetings.
So what are some of those standing items?
Conflicts of interest, there's standard reporting around revenue, audits and inspections, the exercise of delegation, there's a standing financial report, and probably 3 or 4 others.
Okay. In terms of the new business, what are the sources of the new business that you might need to bring to the Commission?
If we're talking about the casino, the source
Yes,
would be
please.
from the casino licensee generally.
As part of that process, either yourself or other officers prepare briefing papers for the Commission.
Correct.
Those papers are prepared and put in the agenda pack.
Correct.
And then do those authors attend the Commission meetings as well?
Only as required.
Okay. And who makes the decision about if they're required?
Probably me, yeah.
When you then have the Commission meetings, is there discussion amongst the Commission members about the particular items on the agenda?
Yes, there is.
And does it ever occur when the Commission members might have questions that they wish to ask the departmental officers?
Yes, it does. And if necessary, the departmental officer will be asked to come and explain the paper.
Okay. And have there ever been situations where the Commission members have asked for more information to be provided?
Absolutely, yes, they are. So if they're not happy in the first instance, the paper will go back and we'll provide additional information.
And if the questions can be answered on the day, the answer is provided?
If
well.
possible,
Yes.
but there are many occasions when the paper had to be resubmitted with more information.
Okay. And is there ever situations where the Commission members might raise something that they'd like to be on an agenda in the future at some point?
Absolutely.
Okay. And so is that another source of the new business that might be added to the agenda?
Yes, it is.
Okay. And that part at least is driven by the Commission members
Yes, it is.
themselves? Okay. No further questions, thank you.
Thank you, Mr Evans.
Thank you, Commissioners. Mr Connolly, just a couple of questions, if I could, to really picking up on the theme from Ms Seward. My understanding is that your evidence accepts that there are a significant degree to which the department is resource constrained in servicing the requirements of the Commission,
Yes.
of GWC to
Yes.
maintain the nomenclature. And that manifests itself, doesn't it, in the reality that there are delays in being able to meet requirements of the GWC from time to time.
Correct.
And there have been a number of requirements which have been put forward by the GWC itself in recent times, I understand it, which remain outstanding. Is that correct?
That's correct.
To instance those, there is, as I understand it, a report by Ernst & Young, which is outstanding at the present time.
That's more recent, I believe. So that, yeah, haven't been.
So
I don't have knowledge of that.
you weren't involved in that.
No.
I'll take that up with someone else. There is something which I think you were involved with, which is KPIs.
Yeah,
and you
that's
referred
correct.
to KPIs in the course of
That's
your evidence. And the KPIs which you referred to are, if I say with deference to Commissioner Murphy, these are requirements effectively of the Auditor General from time to time to provide performance and efficiency indicators in relation to departments and agencies.
That's correct.
And consistent with that, as part of its audit annually, the GWC produces a KPI report.
Yes, it does.
Those are, and we heard some evidence about this yesterday, effectively cognate between the GWC and departmental officers because they achieve the same objective.
That's correct.
Now, those were put, I think, to GWC in the audit report for 2019. A number of questions were asked about the utility of the KPIs. Is that correct?
That's correct.
And the GWC requested, and I think it was first in its meeting of the 25th of August 2018, in fact, for a comprehensive review of the KPIs to be undertaken by the department.
That's correct.
And the department acceded to that request. But that review has yet to be completed, as I understand.
That's how I understand it. It's not completed at this point.
And that was followed up in 2019, it was followed up in 2020.
Yeah.
And the purpose of seeking a more comprehensive set of KPIs was actually to, in a sense, more meaningfully associate KPIs with the function of the Commission.
Correct.
And one of the actual components of the review was a request to define effectively what the role of the GWC was. Was it not? Do you recall that?
No, not specifically. No, I don't know.
That may be a matter for another witness. Can I just pick up one other thing, and it comes from paragraph 87 of your statement. In that paragraph, you say in the second part of the paragraph, I had effective control of the agenda and manner in which items at the GWC meeting were discussed. It's page 11 of 36 in the statement. Do you recall saying that in your evidence?
Yes.
Is it practically the case that, at least more latterly, you have de facto chaired the meeting and run the agenda, whether or not the chair was there in fact?
I think that's practically the case, yes.
Yes. Thank you. Commissioners, we have waxed and waned over different parts of the statement today. Given that, I'd prefer to reserve any further cross-examination to a later occasion.
All right. Yes, thank you, Mr Evans. Commissioner Jenkins?
I just have a few questions to ask whilst they're fresh in my mind. And one of the things is to clarify with you the chronology in regards to what you were aware of. Did you become aware of the China arrests, I'll call them, at the time that they occurred?
When they were made public in the media was when I think I became aware of those, not before.
And I'll have to actually ask for council's assistance here, but that was, sorry, just looking at. About October 2016, am I right in that respect?
I'm council assisting, so if you're going to get any assistance, it'll be from me in the first instance, but I'll have to check with my instructor.
Does that accord with your...
It does. It was 2016 at some point, yes.
Right. And then in... do you recall in around September 2016 that Senator Nick Xenophon was requesting a crackdown on money laundering in gambling venues as a result of allegations that a Chinese
Not
citizen
specifically.
was laundering?
I'm very confident that they would have been circulated to us, but I don't recall the articles specifically, no.
So it's in that context that I just want to ask you about your evidence that you say that it was about since 2017 that you became aware of the issue around junkets and money laundering and criminal activity in gaming venues, in particular the casino. Would you agree that it might have been actually earlier than that?
It quite possibly would have been. It would have been around those media articles. So, yes, I wouldn't disagree with that.
So did you regard it as part of your role, either as Deputy Director General or as Chief Casino Operator, to keep yourself up to date with information about what was happening in the Perth casino and in casinos around Australia generally?
Yes.
And so if we accept that you had that sort of information in 2016, did you do anything as a result of that?
I don't recall specifically. Definitely speaking to regulators in Victoria, which is how I became aware that they were going to conduct an investigation into what happened in China, but and informing the Gaming and Wagering Commission of what was happening. Obviously, they would have already seen that as part of media, but specific actions, no, I don't recall. I'd have to check minutes and other things, have access to documents to refresh my memory on those.
Moving on to the last part of your evidence, questions asked of you by Mr. Evans, I believe it was, and Ms. Seawood. First of all, in respect of what Mr. Evans said to you, and you agreed that the department is constrained in its ability to service the GWC by the department's resources and the GWC's lack of resources.
Mm-hmm. Yes.
So, either as Deputy Director General or as Chief Casino Operator Officer, have you ever recommended to the GWC that it should seek an increase in its funding?
I've recommended to the GWC that it reviews its structures and regulatory processes, which is a process that is underway at the moment. I haven't recommended that they seek additional funding.
Well, why not?
Well, more often than not, when government budgets are released and budget period comes around, departments are advised not to ask for new money, that bids for new money won't be considered. So we're working within the constraints of, as I understand this, we work within the constraints of what we've got. Which is why, largely, casino inspectors liquor inspectors, gambling inspectors became inspectors, and we used them across all of those functions to try and get efficiencies from that group of people using the resources that we already had.
Then going on to something Ms Seawood asked you about, and that was about GWC members proactively asking for further information about recommendations, etc. Can you recall a time where the GWC has actually refused to accept a recommendation that you or the department has put up to them in relation to casino regulation?
Yes, specifically no, but I am extremely confident that there are many times that has happened.
So that was going to be my next question. If you answered yes,
Yeah.
I was going to say then, could you tell me when?
No, but with access to the record, to the minutes, I'm sure that we would find that, yeah. Now, again, that would be for a number of reasons. They were not happy with paper. They didn't see connection between information in paper and the recommendation, or they just weren't happy with the proposal. But many times.
You've talked about, in terms of the detection of money laundering within casinos, the fact that one of the reasons the GWC shouldn't do it is because of the duplication of processes. Is that right?
That's right.
In respect of the Perth casino, it's the GWC and the inspectors who have the power and exercise the power of going into the casino and, when they want to, inspecting the books and accounts of the casino. Is that right?
Yes, that's right.
And that's a statutory power that they can exercise at any time for the purpose of ensuring the integrity of casino gaming. That's right.
That's right.
And there isn't any other authority which regularly exercises that kind of power in the casino, is there?
No, don't believe so. There is another authority that actually gets information in respect of suspect financial transaction reportings and intelligence from AUSTRAC, though.
Which is sorry?
WAPOL.
Sorry, what do you mean by that?
So information, intelligence from AUSTRAC about potential money laundering activities in Western Australia, more broadly, not just at Crown. I believe that that information goes to WAPOL.
Yes,
and has never circulated.
I thought you were suggesting that WAPOL was reporting to AUSTRAC on suspicious transactions. No. So, in that sense, in the sense that it's actually the inspectors and the GWC that have the power to go and inspect the casino books and accounts, you don't see that gives them that gives the GWC a special role in the identification or the detection of criminal offences at Perth Casino, to the extent that those criminal offences might impact on the integrity of gaming?
I still believe that would take skills in order to be able to identify these things. I mean, I can't remember the correct term that's used for structuring deposits and other transactions to avoid requirements, AUSTRAC reporting requirements, but I believe that would still require significant skills and would have a resource implication, no doubt.
All right, so in determining that opinion, have you requested the GWC to instruct the inspectors, or have you yourself instructed the inspectors to go and look at the Riverbank bank statements, for example,
No.
to see whether it's actually that hard
No.
to identify?
No.
have you done anything else to ascertain whether it is actually that difficult to, and whether special skills are required to identify structuring?
No, I've maintained the view that that's somebody else's role.
Just one other issue I might cover off at this point, and it's about the same issues. Was your evidence that you didn't think that it was ever within the powers or capacity of the GWC or the department to identify money laundering at the casino? And we've covered that issue about Riverbank and looking at their accounts. What about the issue of the provision of granting credit to gamblers? Have you ever considered whether that is a way of trying to prevent or reduce the chance of money laundering or criminal, or money laundering in particular at the Perth casino?
No, I don't think I've considered it in that context. Credit, again, those are decisions made by the Commission, and I can't recall actually raising those sort of matters with the Commission in respect of funds advance or credit.
And the same sort of area, no, I won't go there, I might do that at another time. In respect then, finally, in respect to these issues, you're basically saying you didn't get any formal training in respect of either being the chief casino officer or being the Deputy Director General regulation in terms of regulating the casino, is that right?
That's right.
So did you ever look at what training might be available to you?
From time to time, I have looked at training, and I did attend a casino, a gaming regulators forum in 2019. But no, I'd suggest that predominantly no, I didn't look at training. I was too busy doing other things.
So you just didn't have the time to turn your mind to that issue particularly?
No, I don't think so. Time has been a problem.
Sorry?
Time has been an issue, for sure.
So I can just ask a follow-up question about that. And is that, I got the impression from what you said in evidence was that being Chief Casino Officer didn't take up much of your time.
Mm-hmm.
And casino regulation, I can't remember now exactly what
I think I said about 20% in
about
total.
20%. So those issues aren't taking up a lot of your time,
No.
all in all. So what was it about your role that consumed your time?
Through straight after the machinery government changes, absolutely local government and liquor predominantly is what's taking up, or has taken up most of my time.
Thank you, Mr. Conley. That's all that I wanted to ask at this point.
Oh, Commissioner, only to clarify, the issue around the key performance indicators, the question that was asked, they would be the key performance indicators required under the Financial Management Act and audited by the Auditor General.
That's correct. Yeah, that's correct. Sorry.
Thank you.
Mr. Conley, there are just two matters that I'd like to raise with you at this stage. And the first one follows on from what Commissioner Jenkins has been asking you about a role of forensic analysis of the accounts for the detection of the indicia of money laundering. Can I ask you this question? Now, I accept that your general position is, and I'm paraphrasing, and please tell me if this is unfair, that the Gaming and Wagering Commission has neither the capacity nor the necessity to detect money laundering but it does have an audit and inspection function to ensure that the integrity of the gaming operations is protected.
Correct.
Following on from what Commissioner Jenkins was saying to you, and I know that there are lots of ifs in this, but if there were a capacity to do the forensic audits that could detect the indicia of money laundering, might that not have been part of a regulatory function which has as its aim the identification of systemic problems rather than being a law enforcement agency function in itself, but of identifying systemic problems that, let me ask you this question. Are you aware that the Crown Group had an anti-money laundering policy?
Yes.
And was that a part of the Casino Operations Manual?
Only very limited parts of that.
Well, to the extent that it was part of the Casino Operations Manual, might not a facility of that nature been of assistance both to Crown and to the public in being able to detect whether systemically the policies were working?
A forensic
Analysis
ability, absolutely, Commissioner, it would have been. And part of the suggestions that I've had in terms of reviewing was using the available resources we had, but by reallocating people from licensing area and from the current inspectorate and replacing them with people with forensic accounting skills and indeed IT skills, information technology skills, because lots of the information we're getting out of or is available from the casino comes from systems now.
All right, thank you. Now, the second question I want to ask you is about, you'll recall that Ms. Cale asked you a series of questions about, and I think it was in relation to paragraph 22 of your statement, about the main cage and supervision of what was happening in the main cage. And your answer was, well, we want to make sure that things aren't stolen. Can I put this to you, and I'm asking for your view, can I put this to you, and I'll put it bluntly, is it your view that a significant part of the regulatory function is protection of the revenue of the state of Western Australia?
Yes.
Is it your view that the protection of the revenue of the state of Western Australia is a very significant part of the regulatory function?
I would say significant. I wouldn't say very significant. It would be, excuse me, Commissioner, it would be on par with the integrity of the gaming operations, the conduct of gaming, but revenue is significant.
On par with the integrity of, is this the issue of ensuring that the games are played according to the rules which have been set?
Yes.
Anything else?
No, I don't think so. All part of the integrity is the probity of people. So the integrity of the gaming and revenue, I would see as the two highest priorities, two most significant priorities.
All right, thank you. Ms. Cale, anything arising from that?
No, I don't think so, thank you.
All right, Mr. Van Dongen?
Commissioners, I don't have any specific questions for Mr Connolly. However, he did indicate to me at lunchtime that there was something he wanted to raise with me, and of course I've not spoken to him about that yet. So I'd seek 5 or 10 minute indulgence just to speak to Mr Connolly about that matter.
Certainly. We'll adjourn for, 5 minutes? 5 minutes?
That would be fine.
We'll come back at 3:40.
Thank you.
Thank you. Please be seated. Mr Van Dongen.
Thank you for that time, Commissioners. I don't have any questions.
All right. Mr. Connolly, I'm sorry that I can't release you. We will need to hear from you again. You've heard the exchanges, but we've got to the stage where you have free access to your advisors. In the meantime, we'll give you as much notice as we can.
Thank you.
And we will adjourn until 10 a.m. tomorrow.